Hello, I'm Lisa Harker, Director of the Nuffield Family Justice Observatory. Welcome to this webinar on young people in care proceedings. Over the last year, Nuffield Family Justice Observatory has been working on a project on young people, encompassing those in care proceedings and in care, and those receiving support from children's social care. We've been bringing together existing and emerging evidence and insights from young people and professionals. We recognise the need to bring about change in the way the family justice system responds to young people's needs, and to identify ways to improve support for young people across the family justice system and its intersections with the care and youth justice systems. There is a real opportunity to rethink. With others, we are working to explore what is working well and what needs to change, and what is needed for that change to happen. Over the next 90 minutes, we'll be presenting a range of new Nuffield Family Justice Observatory research that aims to understand the reasons why young people enter care proceedings. We'll also hear from professionals and from young people with experience of the care system. And we'll be sharing examples of innovative practice that aims to better meet young people's needs. But first, here's an introduction to the session from Sir James Munby, Chair of the Nuffield Family Justice Observatory.
Welcome to this Nuffield Family Justice Observatory webinar series for the Judicial College. The Nuffield Family Justice Observatory was established by the Nuffield Foundation in 2019 to improve the lives of children and their families by putting data and evidence at the heart of the family justice system. All the people who work within the family justice system, judges, lawyers, social workers, Kafka guardians, policymakers, and more, share a common goal, helping children and their families to thrive in the future. But understanding how to achieve that ambition is limited by a lack of readily available data and research evidence, and too few opportunities exist for those involved to share their knowledge and experiences. The Observatory exists to find and fill the gaps in our understanding of the family justice system, to highlight the areas where change will have the biggest impact, and to foster collaboration to make that change happen. The centre of its lens is on the family courts, but its focus extends far beyond this, to understand the support that children and families need before they reach family courts, and what happens after they've been through the family justice system. It is entirely independent, working with leading academics, reviewing evidence from around the world, and commissioning new research where it is needed. During the pandemic, it has swiftly turned its lens on the impact of COVID-19 on the family justice system, hearing from those experiencing the issues firsthand, not just professionals, but also importantly families, and identifying the opportunities and challenges abrupt changes to practice have offered up. Throughout this series, you will hear from a range of experts and others with experience of the family justice system on a range of issues, from the immediate impact of COVID-19 on hearings in the family court, to how best to manage contact between children in care or adopted and their birth families, and more. As a family judge, I need no persuasion of the importance of the Judicial College. In my new role with the Observatory, I have rapidly come to appreciate not only the importance of research, but also just how valuable it is in illuminating much that is obscure in the working of the family justice system, and in enabling us to see how things can be improved. I hope that this webinar series will be the beginning of a long and fruitful collaboration between the College and the Observatory.
Thank you, Sir James. We will also be hearing reflections from Sir Andrew McFarlane, President of the Family Division, later on in the webinar. So let's start with an overview of young people in care proceedings.
The number of 10 to 17-year-olds subject to care proceedings has almost doubled in the last 10 years, rising faster than for any other group. Older children now make up around a quarter of all children in care proceedings. Many older children have faced long-term neglect or instability and come from families with continuing domestic abuse, substance misuse, or mental health problems, and who are managing the impact of poverty on everyday life. Their early experiences of instability, loss, and trauma mean they are more likely to exhibit challenging behaviours and be vulnerable to risk in adolescence. Extrafamilial risks from outside the home, such as criminal or sexual exploitation, rarely happen in isolation. Children with long-standing intrafamilial issues at home are more likely to face such risks. This raises questions about whether earlier support could prevent problems escalating. We don't know enough about young people's long-term outcomes after a care order is made. However, research does highlight a lack of placements offering the right care. This means that some of our most vulnerable older children and young people are likely to be living far from home in unsuitable places. Children's services, youth justice, and CAMS are often all involved in their lives, but there is a lack of joined-up care designed around their needs. Nuffield Family Justice Observatory is working with young people and professionals to identify what needs to change and how to make that change happen.
Before we move on to the presentations, I'd like to say a few words about the format of today's event. There are several hundred of you attending, and while we won't be able to see you during the event, we do want to hear from you. So please share your experiences in the chat tab. We'll also be putting questions to our discussion panel during the last half hour of the webinar. So please put any questions you'd like to see raised in the Q&A tab. All of the comments and the questions will be read by the Nuffield Family Justice Observatory team, helping to shape future research and webinars. We are recording today's event, and it will be available via our website if you'd like to revisit any of the content. I'm now going to hand over to Alice Rowe, researcher at the Nuffield Family Justice Observatory, who's going to talk about two new pieces of research that provide the first national overview of older children and young people in care proceedings in England and Wales, including new research which explores their health service use in Wales.
So I'm going to talk about two pieces of research that we've done using Kafka and Kafka's Cymru data to build a population level picture of young people in care proceedings in England and Wales. So we know from other data sources that there has been an increase in the number of older children entering care proceedings and coming into the care system. But we looked at the Kafka's data in order to build a more detailed picture about who these young people are, where in the country they are living, and what the outcomes are from their proceedings. So what did we do? In the first study that I'm going to talk about, we use administrative data routinely collected by Kafka's and Kafka's Cymru to look at population trends in the number of young people in care proceedings and case outcomes. An anonymised version of the Kafka's data is available for research purposes held in the privacy protecting SAIL databank. So we looked at all cases involving 10 to 17-year-olds who were subject to Section 31 care proceedings between the 1st of April 2011 and the 31st of March 2020 in England and Wales. We carried out primarily descriptive analyses to quantify case volumes, to look at the proportions of young people compared to all children in proceedings, and to calculate incidence rates over time. So in this research, and in all the research that you'll hear about today, we define older children and young people as those aged between 10 and 17 years old. This broadly reflects scientific consensus that the period of adolescence begins at around 10 years of age, and legal definitions of children in the Children Act as those under 18 years of age. So before I share some of the findings from this work, it's worth bearing in mind a couple of limitations to using Kafka's data for research. First, and this is particularly relevant for older children in care, Kafka's data does not include children who come into care under voluntary Section 20 or Section 76 arrangements in England and Wales. We know that the majority of teenagers who do come into care do so under these arrangements, so it's important to stress that this research focuses only on those children who come into care through care proceedings and through the family courts. Second, the Kafka's data holds very limited information about children's ethnicity. This is a key limitation, as we know that there are disproportionate numbers of Black and other ethnic minority groups in care, and that there may be stark differences about their journeys into and outcomes after proceedings that it's important for the family justice system to consider. Improving this data is a key aim of the FJO, and we're hopeful that through data linkage, we can start to build a better picture of the ethnicity of children and families in the family justice system. And finally, the Kafka data does not record child placement information alongside final legal order. So while we can say what the legal outcome was from a case, we don't know exactly where the child ended up living. So bearing all that in mind, I'm now going to provide a brief overview of the main findings from this work, but I do encourage you to take a look at the main report available on our website for more detail of the analysis. So first, we calculated incidence rates of the number of young people in care proceedings per 10,000 adolescents in the population. So this tells us if the number of young people in care proceedings is increasing relative to the general population. So we can see that there has been a sharp increase in the last 10 years, meaning that young people are now more likely to be subject to care proceedings than they were 10 years ago. This increase is noticeable in both England and Wales, and the rate of increase has been broadly similar in both nations. So you can see from the graph here that there was a particularly sharp increase around 2014-15 and 2016-17. It's of note that this coincided with changes in practice in relation to voluntary Section 20 and Section 76 arrangements, and a likely increase in the number of these cases coming to court. We know from children's social care data that there was a decrease in the number of children coming into care under these arrangements around this time. So this may be one driving factor in the increase in the number of young people in care proceedings. But we can also see that even prior to this change, the rate of adolescents in proceedings was increasing. So next, we looked at the number of adolescents as a proportion of all children in care proceedings. So in England in 2012, 10 to 17-year-olds made up less than a fifth of all children in care proceedings. By 2020, this had increased to 27%, over a quarter. This represents a significant shift in the age range of children appearing before the family courts. We also noticed a sharp increase in the number of 15 and 16-year-olds who were subject to care proceedings that had increased substantially over this time. There was an increase of almost 150% in the number of 15-year-olds in proceedings, and an increase of over 250% among 16-year-olds. There is a need for further research in order to understand the reasons why older adolescents are being brought into care proceedings in increasing numbers. So when we look at Wales, we see a similar picture. In 2011-12, adolescents constituted just 18% of all children in care proceedings. By 2019-20, this had increased to 23%. So young people now make up just under a quarter of all children in care proceedings in Wales, which is a slightly lower proportion than we see in England. So we also looked at regional differences in the number of young people coming into proceedings. And while all regions have seen an increase over the last 10 years, the rate of increase has not been the same across the country. We can see that the North East in particular has a higher incident rate over time, which is the dark blue line in the graph. And this divergence becomes particularly apparent since 2015. The North West, Yorkshire and the Humber, and London also have slightly higher than average rates, while the South East and East of England have one of the lowest rates. So the reasons behind this variation and the higher rates in the North East are not clear from the data and warrant further investigation with local stakeholders to explore. We know that the North East also has the highest rates for all children in care proceedings, and that deprivation may be a key factor in this. The North East has had the biggest increase in child poverty rates between 2015 and 2020 out of all regions in the UK. And we also know that the North East has one of the lowest proportions of all children who are looked after on Section 20 arrangements, which may explain in part why we see higher rates of care proceedings in the region. So overall, we can't say from the data what drives higher rates in one area or lower rates in another, but it's important in order to better understand children and families' experience of the family justice system that we explore this further with local stakeholders. So in Wales, we explored local area variation by looking at the 3 district family judge areas. At the beginning of the study period, all 3 areas recorded fairly similar incidence rates, but from this point onwards, we can see some divergence. So rates began to increase in Cardiff and South East Wales and in North Wales, while in Swansea and South West Wales, the rate of increase has been much slower, with fairly minimal change over time. So we also looked at some characteristics of the cases, including who young people were being brought into proceedings with. And we found that the majority of young people, just over 70%, were brought into proceedings with siblings. This is a slightly higher proportion than for children of all ages. In terms of the gender distribution, there was an approximately even split of boys and girls, which reflects a similar pattern to that which we see for all children in care proceedings. So finally, we looked at final legal order outcomes that were recorded in the Kafka data. The most common outcome at the close of proceedings for young people was the care order, and this occurred in around 60% of cases in England and 80% of cases in Wales. This has been relatively consistent over time. And as I mentioned earlier, we can't say from the data exactly where these children were placed under a care order, be that in foster care, residential care, at home, or with family members. In England, we also found that there has been a notable increase in the number of younger adolescents, so those aged 10 to 14 years, who were placed with family members, rising from 16 to 23% over the study period. We know relatively little about the journeys of young people into kinship care or what their outcomes are, so this will be an important area for further research. We also found that in England, older adolescents, so those aged 15 and above, were slightly less likely to receive a care order. In particular, around a third of 16 and 17-year-olds, for their case resulted in no order or the case being withdrawn. And while there may be various explanations for this, including them aging out of proceedings, it raises questions about the grounds for bringing older adolescents into care proceedings and the capacity of the family justice system and the final legal orders available to meet their needs. So the second study that I'm going to talk about, which was conducted by the Family Justice Data Partnership, looked at the health of young people in care proceedings in Wales. By linking Welsh health data to Kafka's Cymru data in the Sale Data Bank, we've been able to provide a descriptive overview of the health and health service use of young people in the year prior to care proceedings being issued. So this was compared to a comparison group of young people in the general population in Wales who were not involved in care proceedings and who were matched according to age, gender, and area level deprivation. So to look at healthcare use, we explored the number of older children and young people who had at least one hospital admission, A&E, or GP attendance during the year prior to proceedings. And as you can see from this figure, there is an overall picture of higher healthcare use for the cohort of young people in care proceedings compared to those in the general population. And we see this across healthcare services, including hospital admissions, A&E attendance, where over a third of the cohort had attended A&E in the year prior to proceedings, and for GP appointments, with almost all young people in the cohort having a record of a GP appointment. So next, the research team looked in more detail at the reasons for these visits and the health conditions that were recorded in the data. And they found relatively high prevalence of certain conditions among young people who were subject to care proceedings compared to those in the general population. It was particularly concerning that when looking at the GP data, over half of young people in proceedings had a diagnosed mental health condition, compared to around a third in the general population. And this points to the mental health needs of this group of young people and further emphasises the need to ensure proper mental health support is available before, during, and after care proceedings. So when looking at the reasons for hospital admissions, it was noticeable that the most common condition recorded, and where there was the largest difference compared to the comparison group, was for injury and poisoning related conditions. Further work is needed to explore the nature of these conditions in more detail, including their causes, but this may include, for example, self-harm, accidents, or assault. We also see a fairly big difference in hospital admissions for mental disorders, although the overall number here is very small, with just under 2% of all young people in care proceedings being admitted to hospital for mental health reasons. It does suggest that this group of children are more likely to be admitted to hospital for their mental health compared to their peers. So finally, looking at the conditions recorded during A&E attendance, we see a similar picture of heightened health vulnerabilities in the cohort group compared to in the general population. The most common reason for A&E attendance was for wounds, and there was a particularly stark difference between the cohort and comparison group for poisoning or overdose-related conditions, which may relate to drug or alcohol misuse problems, and for attendance at A&E for mental health issues. So what does this tell us? By using national Kafka data, we've been able to look at the overall trends of young people coming into care proceedings, and we found that the number of 10 to 17-year-olds in care proceedings has approximately doubled in the last 10 years. However, this increase is not being felt equally around the country. So further work is needed to better understand the drivers of this increase and the outcomes of young people in care proceedings, which should include hearing from young people themselves. By linking Kafka's data to other administrative data sources is one way that we can provide a better picture of and better understand the needs of young people who come into proceedings. So by linking to health data, we've been able to show that these young people have more health vulnerabilities, particularly around mental health, when over 50% had a diagnosed mental health condition, and are more likely to be involved with both primary and secondary healthcare services compared to similar young people in the general population. By better understanding the health needs of young people in care proceedings, those involved in health services can work with children's social services and the youth justice system in order to better identify and support those at risk. Thank you.
Thank you, Alice. We'd like to hear your thoughts on these findings. Don't forget to add your comments in the chat and put your questions in the Q&A tab. I can see that some of you are already doing so, and we're really keen to hear from you. What is particularly striking from our work on young people is that when speaking to judges, social workers, youth workers, and other professionals, there's an almost universal sense that the options open to them don't fully meet the needs of young people. There is a sense of frustration that their contribution is too limited or the options available to them are too restricted. Young people's needs in some ways are very straightforward. For example, to have sustained trauma-informed support, strong relationships, and a network of people, including their family, that stick with them through difficult times, and a voice over what is happening to them and the decisions being made about them. We've been talking to professionals about current problems with the family justice and child welfare systems. Let's hear from a few of them now.
We've actually got a group of young people, and some of whom have experienced lots of early childhood adversity, might have a whole range of needs, have circumstances that need addressing, and yet as a group we know very little about their needs.
Many children are in stable placements, but there is a group who are moving and who have some of the worst outcomes.
Either experiences of seeing children who I'm aware of being in foster care, then seeing them appear in residential care, and then receiving papers to pursue an application for a secure accommodation order, for example. So this trajectory, this sort of sad conveyor belt where suddenly the system says there's nothing more to do, say, for ask the court for authority to, lock this child up for a period of time.
When you're only intervening with young people starting to get involved when they get to crisis point, because the focus becomes on the risk, what you end up with is then not paying enough attention to people's strengths, to their care, to their responsibilities.
Minoritised children and young people, where are their voices and experiences being amplified, and who's talking about the structural and systemic inequalities which continue to permeate throughout all of those various different systems?
Safeguarding's retained this almost uniquely binary, quite quaint idea that you can neatly delineate between childhood and adulthood, as if adolescence isn't the very process of transitioning from one state to the other. Inherent in that is quite a binary notion of victimhood and villainy.
Treatment of children, I think, in the youth justice system is often conflicted. The children involved in the youth justice system have a dual status. They're both a child, but then they also have a status as an offender or a suspect. So that can be in conflict.
There is something about the increased professionalisation of social work, of youth justice work, which I think has tended to get in the way of, let's say, caring relationships. We need to ensure that professionalism allows for caring too.
A cautionary message to all of us to be really careful and not just assume that contact with family justice or youth justice or child welfare system is a good thing.
Thank you to all those professionals for taking part and sharing their views. You can watch the longer film on our website. Now let's hear from 3 young people with experience of the care system. In conversation with each other, they provide a valuable insight into their experience of current systems.
But in terms of like support and stuff, I felt supported by like my guardian. I think the one thing that I would say was she actually like listened to me. Like I could speak to her and I would tell her, I don't want this, or I don't want this, or I don't want, like some of the things, like sometimes it would be a bit tough, like especially with my mum, so I might be like, well, I want this to be said, but I want it to be said in a way that doesn't make my mum look like a crazy person. So sometimes I think the way that she was really sensitive with the information that was given to her, and the way that she responded to the information that was given, she was like quite supportive, and yeah, I felt heard. I think that was the most important thing, was that I actually felt heard.
You are just like a case and you're 1 of thousands. It's like you're a number on a piece of paper, that your feelings aren't really taken into account. They just see the case and they see what needs to be done and what boxes need to be ticked. You're no longer a person. You're not even a number, you're a piece of paper, and I think that's the hardest part.
I agree, like it is very impersonal, and I think sometimes, like, I know that there's like, it's like power struggles between who do we listen to? Are the parents the ones that we listen to, or do we listen to the children? Because the parents are supposed to know better, or the parents are the ones that make the decisions that benefit the child, right?
Yeah, I get what you mean. A lot of people's and children's voices are taken away when it comes to the court. It's kind of like they're the adults, they know best, and really you're not even informed of the decisions till they're already made.
In my experience, like the lawyers that we had, I don't even know. The last one that I remember, I just felt like he was not supportive of my mum at all. Like, and he was just basically like, yeah, just sign the papers. Don't object to anything. Just do everything that they say. Like just, and I was thinking at the time, I was just thinking, well, for me, I was just like, that's the right thing to do. But when I think about it, it's like, actually, no, like, I believe that you should be trying to help this woman to fight for her kids, and even try to support her and help her realize what she needs to do. And, you know, like, obviously it's not, I don't know what the lawyer's jobs are in that situation, but from a humanity point of view, if you can see that someone has needs, or someone needs help, and you're a person that is actually representing them, you would put those things out there, let people know that actually this isn't just someone that doesn't want to be a parent. This is someone that actually is having a difficult time at the moment, and, you know, they don't really know how to navigate through this part of their life. And my mum didn't have that at all. Her lawyer was just like, yeah, just turned up at the court with his papers all over the place. and just was like, yeah, just give up the kids. And it was for me at the time, I was like, yeah, because it just meant that my mum didn't have to go through like literally an actual fight. But at the same time, as it was like, I felt like for my little sisters later on in their life, they might feel like, well, my mum didn't even fight for me. Like, she was just so willing to just be like, yeah, just let them have them. And it wasn't like that at all. It was more of a, right now, we need something. We need something right now.
You start to explain something, and the first thing that is said, the person that you're saying it to builds an entire story based on that one sentence instead of actually waiting to hear how everything goes along. There's so much that they're not allowed to reveal and they're not allowed to say, especially within their personal circumstances, that they are not themselves when they are in their job. They're not themselves. The people that we're working with, if you get to know their age or if they're married or little bits of information like that, that's better for you. But we don't get that information. We're sat with someone who has a whole caseload in front of us, and we're barely even allowed to know their details, their simple information, because it's protective of them. And obviously it's understanding, like it's understandable due to safeguarding and risk assessment and all of that. But on a relational level, if you want me to relate to you and you want to connect with me, you need to give me something to relate to. You need to actually throw something out there that I could latch onto. Like,
I want you to trust them, but they don't give you anything like to work with. Like, it's very, well, I know everything about you, but you can't even know my middle name kind of thing. And it's kind of like, how do you ever expect to have a relationship with a young person or even a child? What I think they forget, and this isn't just social workers, foster carers, care homes, wherever you end up, I think they forget that they're effectively raising this person to go out into the world and have their own family, have a job, and they need to help them move past their traumas to be able to do that.
It's a very big misunderstanding. There's a very big misunderstanding between the professionals working with the families, and especially the ones that have to relay the messages for the families and on behalf of the families, because these people that are basically delivering this message, they're carrying a very fragile piece of glass, and most of these members of staff, they just bump it into everything, they knock it, they change it, it don't matter, it's nothing. Like, and that is someone's life, that's a future, that is our future.
If a kid is telling you that, Mum, I need to see you 3 times a week so that you can know who I am, or 5 times a week and spend time with you, parents be saying, oh, I gotta work, okay, but when that kid is now smashing up teachers at school because that kid is so angry at the world because they don't get to spend any time with their parents and they actually want to be seen and heard, like, everyone acts like things don't make sense and no one is listening. We're letting people know that actually, before you even go and look at the issues that children have, let's look at the parents. How do we support parents to be better parents? And I know that they will say, oh, well, they do this and we got this and we got that. They're not working. Clearly, the systems are not working. Whatever has been tried in the past is not working. And no one has stopped to think, actually, what are we doing wrong here? Like, why is this system not working? They just keep going.
I just got to jump in and say, I don't think there should be a timeline. I think it should be, well, there shouldn't be a physical timeline as such. I think there should be a timeline based on needs.
The basic needs aren't met. Like, a lot of these young people who are leaving at 25 that still need the support, that could be prevented. Like, if they actually provided the support and met the children's needs from day dot of them coming into the system, they'd already be prepared enough to then, even earlier than 25, go off. Instead of throwing you into the deep end, they should work with you from day dot coming into care. I mean, when I left, I'd never even heard of council tax, like, and all of a sudden you're supposed to just work life out. They just throw you into the deep end. There's no preparation. For me, with my own children, they would always be taught about the real world and the practicalities of life. Not just, oh, you're 18 now, go live on your own. You've turned 25, you can figure it out. It doesn't work like that. That cycle, as I'm a prime example of that, or at least I like to think I am. Or there's the other cases where you see these care kids that have gone on actually to just do exactly the same because they were never taught a different way. And then they lose their kids, and then their kids lose their, and it's just a vicious, never-ending cycle. Somewhere along the line, somebody's going to have to go, enough's enough, and make some changes, because at the end of the day, it's not just this generation's lives that's been ruined by it, they're ruining many to come after.
We are very grateful to Aikisha, Caitlin and Mike and the other young people we've been speaking to for sharing their experiences. We'll now take a look at some new research that aims to help us find out more about why older children and young people are in care proceedings. We'll begin with a case file review presented by Jordan Rehill, researcher at the Nuffield Family Justice Observatory. Following this, Celia Parker and Joe Tunnard, Senior Associates at Research and Practice, will present findings from an in-depth audit involving older children who were subject to care proceedings issued by 4 local authorities in England and Wales.
This case file review, along with other work presented in the session, is part of the long-term focus of the Family Justice Observatory to understand sort of what is working well in supporting older children and young people, what needs to change, and what is needed for this change to happen. Before I begin, I'd just like to thank Her Honour Judge Carol Atkinson and Lindsay McHugh on behalf of the authors and the NFJO for their support and assistance in accessing the case files at the East London Family Court. So for this particular report, we reviewed applications for care proceedings relating to 73 older children and young people aged 10 to 17 received by the East London Family Court between July 2019 and July 2020. And by reviewing these C100A applications, which most of you will know will include information about the grounds for proceedings and also the age and gender of the children included in the application, what we really wanted to do was start building a more detailed and nuanced snapshot of what's going on in families' lives at the point care proceedings are issued. And with any sort of local study such as this, there are a number of limitations. So number one, our study is limited by its small sample, which consisted of cases in one core area across a 1-year time frame. It's also limited by the information contained in the C100A application forms. And though these forms provide some valuable insights as to why these cases are being brought to court, they do not provide a complete overview of a family's history or their prior involvement with children's services, and nor do they contain information about the outcome of proceedings. That being said, the analysis of these forms allows us to draw out live, current needs of older children and young people, as well as their families, and reflect some important findings identified in similar case reviews carried out in different local authorities across England and Wales. So what do we know about the young people and their families? So we know that almost all of the older children and young people in our sample have been known to children's services for several years before proceedings were issued, often since they were young children or infants. And often in a number of cases, there was evidence of chronic neglect that had been going on for much of the young person's life. As well as this, we often saw that parents of these children had significant and long-standing vulnerabilities, including substance misuse, mental health problems, and domestic abuse. And this was often linked to the parents' own experiences of trauma and loss. And what we also saw is the young people in our sample had often experienced high levels of instability and loss and complex trauma from a young age. And we know that, from wider evidence that these experiences are highly likely to affect behaviours and vulnerability to risk in adolescence. And turning to why proceedings were issued, what we saw was over half of the children and young people involved in proceedings in this period were involved with siblings. So in all but one case, the welfare concern was shared across sibling groups. So several cases were brought to court because of a breakdown of informal family care arrangements, often because carers struggled to manage more challenging behaviours in adolescence. What we also saw was the concerns around extrafamilial risk often co-occurred with or were underpinned by intrafamilial concerns. This included, as mentioned in the sort of previous slide, experiences of chronic neglect and abuse, complex trauma, instability and loss, which are highly likely to affect challenging behaviours and vulnerability to risk in adolescence. So in terms of this extrafamilial risk or concerns, we saw that proceedings were often issued at a moment of crisis or when the risk of extrafamilial harm became too great, and opportunities to intervene earlier may have been missed or may have been unsuccessful. So in these cases, the young people were often facing multiple risk factors linked to criminal exploitation, gang or criminal group involvement, child sexual exploitation, school exclusion, and behavioural and mental health difficulties, as well as issues of criminal behaviour. And I think the really important point to take away here is though we're seeing proceedings issued because of risks or harms from outside the home, these risks are nearly always preceded, or were nearly always preceded, by long-term concerns within the family. This extrafamilial harm does not exist in a vacuum. So this case file review should really be seen as one of the first steps, providing live, current information to guide our thinking about why older children and young people are coming into proceedings. So I'll now hand over to Celia Parker and Joe Tunnard from Research and Practice, who will provide a sort of deeper dive into some of the issues I've discussed, thinking about the outcomes of proceedings, as well as young people's subsequent journeys. And they'll do this by drawing on the findings from their local authority case audit. Many thanks for your time.
I'm going to tell you what we did and what we found. We prepared an audit questionnaire to consider the circumstances of children and families before, during, and after care proceedings. 4 local authorities, all with areas of high deprivation, 3 in England, North, South, and London, and 1 in Wales, completed the audit from their records on children aged 10 and over where care proceedings were issued in 2019-20. We analysed the audits for a total of 73 children from 49 families. Very few of the children, just 6, were single children. The rest had brothers and sisters, some in proceedings, some not in proceedings. Just over 2/3 of the children were in the 11 to 13 age range. The majority of families were known to the local authorities, 82%, and 32 of the 49 families had been through all stages of support. Half the families had children in care already at the start of proceedings, and 1/3 of the families were actually in repeat proceedings. The time between the proceedings varied from 1 to 12 years. The reasons for proceedings included 78% due to neglect, 49% due to domestic abuse, 43% physical harm, and 10% sexual abuse in combinations, and this gave rise to 100% emotional harm for those children. The issues affecting parenting capacity were almost 1/3 with substance misuse, almost half with cumulative trauma, and just over 1/3 with poor mental health, again in combinations of those 3. Trauma was a major issue for the children and many of the parents. 25% of children were also affected by extrafamilial safeguarding concerns, criminal exploitation and sexual exploitation. This affected 4 boys and 4 girls. 1 girl and 1 boy had spent time in psychiatric hospital as inpatients, 1 on a section. Just over half of the children ended proceedings on a care order. Mostly they were fostered and some were in kinship foster placements. Counting the kinship foster placements, just under a half remained at home or living within the family network at the conclusion of proceedings. We found that the most vulnerable children had had the most placement moves, and a lack of suitable accommodation to meet their complex needs, secure and other types of accommodation, was very evident. The most stable placements for this group were kinship placements. It was difficult to get a good picture of youth justice involvement, but youth offending teams were involved with 16%, that's 12 of the 73 children. We also noted 9 families where the parents were involved in the criminal justice system. School exclusion was a clear factor for those with most vulnerability to extra-familial safeguarding concerns. There were 7 permanent exclusions and 11 short-term exclusions. We were surprised to find no mention of the Education Welfare Service beyond 1 prosecution for non-school attendance. The most striking thing in undertaking the analysis was the trauma affecting the children and the parents. And I'm now going to hand over to Jo to talk about our reflections and recommendations.
We have 5 key points for today, arising from exploring with the local authority auditors and senior managers this small piece of the huge jigsaw that is safeguarding work, both within families and beyond families. We hope that something chimes with some of your work, in court as magistrates and judges, and out of court as professionals in the local service network. First, we make a plea for renewed focus on early attention to parental needs. Children in the audit needed their parents to be well enough and to be well enough equipped to care for them safely. They needed parents to be helped with the struggles of life marked by poverty and disadvantage, and with parenting made more difficult by substance misuse, domestic abuse, poor mental health, and learning difficulties. The audit confirmed that effective help takes account of what parents want from services and of how they might respond when they feel under threat or in stress. Increasingly, we know about the value of trauma-informed practice and of help that is proactive and offered sooner rather than later. And the second point is the importance of fostering strong and enduring relationships. Some children in the audit were clearly relieved to be in care, to feel less burdened by what they had been struggling with over a long and unhappy period for many of them. But we saw too how these older children were drawn back to the place that was home and to the people who were family. They wanted to stay in touch, and they and their parents needed help to deal with the tensions, the emotions, the risks and the benefits of wanting to make things work better. The audit showed the value here of family group conferencing. This achieved something for children almost every time they were used. A positive move from one parent to the other, continuity while a plan was developed, long-term care from a godparent or a family friend, contact re-established with the lost side of the family. In the local authority that used FGCs the most, this was an embedded way of harnessing strengths within the family network. And crucially, the work was led and backed by policies and by strong leadership committed to a family inclusive approach. Third, we say something about better support needed when proceedings end with a supervision order. As families adjust to the new way of being together, how can we offer the best possible chance of their adjusting well? How do we stop 1 in 3 cases coming back to court as repeat proceedings, with the added heartbreak and sense of failure for all involved? Do we need to put more emphasis on the assistance, advice, and befriending side, whilst not forgetting the supervision side? Exploring in court and out of court the practical and emotional help that each child, each parent might find helpful, and finding ways of providing this for them. Fourth, a plea for sufficient, suitable residential provision for older children with complex difficulties who need help away from home. This is about local authorities having ready access to small, safe, local specialist children's homes, with children staying close to where they belong, help to deal with negative past experiences, get therapeutic help, make up for lost education, develop their talents, feel inspired and confident about the future. It's also about local authorities having access to secure accommodation when children need that for welfare reasons. And it's about knowing more about the experiences and outcomes the children held in the youth secure estate for offending reasons. And last, for now, a point about the involvement of different partner agencies. We looked in the audit for collaborative work with education, health, youth justice. And we saw it too for a handful of families with the family court, because two sites offered parents in care proceedings the FDAC approach with its specialist multi-agency and multidisciplinary team working closely with the trained FDAC judge. But we're going to end on a point about the universal service of education. So we saw how often school acts as a haven, a place of safety for children, and a source of support for parents too. But we saw that absence from school can increase vulnerability to extrafamilial harm, especially when the absence coincides with the child being missing from home, hanging about with peers and others involved in risky behaviour. Our specific recommendation here is that any proposal to exclude a child from school must trigger a multi-agency response. The conference, we say, should be required to consider the risk of exclusion leading to or increasing extrafamilial harm, and to examine the likely impact on the child of being rejected by their school. Because almost certainly, rejection from school will be coming on top of earlier rejection by one, some, or many others in their life. So we say it cannot be right to punish children, punish their parents in this way. Well, there's plenty more in our report. You'll find there more details about the statistics that Celia covered, and you'll also find a selection of case studies that we hope will convey a strong sense of the human stories behind the stats, of the lived experience of these older children and their families, and of the challenges and achievements for everyone involved, families and professionals alike. Thank you.
Thank you, Jordan, Celia, and Joe. So we know there are many challenges, and let's now hear from professionals who are implementing innovative practice to address them. We're going to hear about projects in Coventry and Warwickshire and in Newport.
The concern that I personally had was that social workers, sometimes guardians, were saying to me that young people, perhaps of 14 years, 15 years, that it was all too late and that nothing could be done. They were lost in the system, lost in society. I didn't actually agree with that analysis. I realised that if we're looking at teenagers of that sort of age, that time was limited, but I didn't see that we should write them off. Quite the opposite. I thought we should work with them and see whether some improvement could be made in the short time that we had available. And we decided that we would adopt the practices that we had developed in Coventry, in the Family, Drug and Alcohol Court. We call it FDAC, the Family, Drug and Alcohol Court. And the key elements of FDAC are meetings with the judge and the tailor-made, focused support, wraparound support for the parents. So we already had that model up and running in Coventry. And we wondered whether we could adapt and change that approach so that it would help young people in proceedings. The first key point is a document called My Plan. The My Plan questions are very simple. They ask the question, what do I want to happen in my life is one of the questions, and why. Well, when the young person first fills in that form with the social worker, he will say something like, I want to go home, or I want these proceedings to come to an end. And as a judge, you're able to say, well, that's what the family proceedings, the care proceedings are all about, and I will make a decision about that. But I'm interested in you. I'm interested in what you want to happen in your life. And that's when you can visibly see the young person's shoulders just going down, they're relaxing. And one young man said to me, I just want to go to school because I want to get on well with my education, but I can't get there. My mum is busy with my younger sister, and she doesn't have time to get me up and get me to school, and I have to take 2 buses, and I'm always late. And so he said to me that what I really want is a bike. If I had a bike, I could cycle to school, and I would be on time. So we were able, the judge, I was in fact the judge on that occasion, I was able to speak with the social worker and say, well, surely we can get him a second-hand bike and a helmet, and perhaps even get him to some road safety classes, so he's safe on the roads. And we achieved that. He got a bike. Because it was an old bike, he kept on getting punctures. So in fact, it was his dad who showed him how to change the tyres and to mend the punctures. So that was something which he could do with his dad. And this young man arrived regularly at school on time. So much so, he told me in one of the adolescent project meetings with me that his teacher had bought him a bacon cob for being arriving on time for school for a whole half term, I think it was. So yeah, little things which can make such a difference to a young person. And in the end, it was an entirely successful outcome, because that young person was able to stay at home. He was able to demonstrate a level of independence, and it turned the case around. So
young people have shared more with their social workers after the meetings with the judges. What we've heard from social workers is that because they're taking the young people to those meetings and they're then taking them back to placement or to home afterwards, it's an opportunity to talk in the car, and young people tend to speak during car journeys because there's nothing else to do. So so they have opened up more about the meetings that they've had with the judges, and it's had a positive impact on the relationship that they've had with their social workers. The other thing that we heard from solicitors was that they felt that the young people had become more confident in speaking to their solicitors and giving their own instruction. So whether they separated from their guardian or not, they were more confident in speaking to their solicitors and saying what they wanted their solicitors to say on their behalf, which again is a really positive thing for young people to feel, is that they feel that they can give those instructions to their solicitors and ask that their solicitors tell the court, their parents, professionals working with them, what their views are. And when we're looking at children or older children that come into the courts, they tend to have very complex needs. They tend to have a lot of anxieties, a lot of issues that result from their involvement with their families, with the wider community, in schools, social isolation, and having tools that enable them to better engage in their process, to better engage in the work that they're doing with professionals, can only be a positive experience for them going forward.
So Newport, as some will know, is a small city in southeast Wales. We have a particular demographic. We've got significantly higher numbers of children from all sorts of backgrounds than most other Welsh areas, so quite different. And I suppose the big challenge for us in relation to partly what I'm talking to you today was specifically around placements for older children. And those are placements that very much are those children who fall somehow between children's services, youth justice services and child and adolescent mental health services. And we, like many local authorities, were seeing increasing numbers of children where provision and care for that group was really challenging for us to access. We're only at the beginning of this project. We haven't got to the end yet by a long, long way. So what we've been doing is working in partnership with our health board and Iron Bevan Health Board and the other 4 local authorities in our area to look at how we build a resource that can meet that need. And it came about really because we and the other 4 local authorities in our area were repeatedly having crises, the only way to describe it, for children who were ending up in inappropriate care. So they were ending up potentially on a paediatric bed or in an unregulated placement, and we were unable to meet their needs, and we were unable to secure any sort of appropriate placement for them outside of the authority. So the Change Project has been very much about building a resource that can meet that need and fill that gap. This is a partnership development for a provision called Windmill Farm. I have to say it's still very bumpy and really hard, but it's something that we're trying to do. What we've been trying to do is come together earlier to provide a joint provision where we're all engaged and we're all thinking in the same way to try to resolve the challenge that we have. We're trying to stop children being stuck in inappropriate placements without the right care. Simple as that, really.
We were one of the local authorities that had the resources, the staff, and the ability to provide a regional home for children, older teenagers with complex needs, prevent them going to secure homes or to help them come back into the community if they've been into secure or hospital settings. So it's still in the early stages. We haven't opened the home at the moment. I've got a number of other young people's children's homes within Newport. This is different because this is with health. So with our other homes, the children would have to access health through waiting lists and referral processes, and that can cause a lot of delay for these young people. With Windmill Farm, health are on board with this, so the young people will access specialist CAMs or any of the services, attachment and trauma services that they need once they're placed within this home. So it's about joint working, and that's not been done before. It's one of the first ones within Wales to look at this as a project to see how we can work together. I hope that there's be a reduction in the children having to go into secure units or into hospital beds. I'm hoping that if young people have had to go into them, that we can find this will be appropriate accommodation for them, so they're not in unregistered or inappropriate accommodation. That there's a reduction, there's a better care, that we've got more placements available, and it's a home for these young people whilst we reduce their crisis. It's really important that we drive this forward. We need placements for young people, appropriate ones within Wales, within their regions.
Thank you to those professionals for sharing those examples. Now, I'm delighted to say we have a message from Sir Andrew McFarlane, President of the Family Division, reflecting on what he's heard in this webinar.
There's an enormous amount of data here and research here that's been collected and then delivered to us in the course of an hour. It's very rich, and I'd encourage those of you who are interested in these issues to look at the raw research that the various researchers have been talking about. In a way, none of us who are working in family justice should be surprised by much of what we've heard. It is a picture of what we see, and to that extent, we should feel reassured. I suspect that wherever we are in the country, it's in tune, sadly, awfully, with the needs of these older young people who come before the court. But it's very, very useful to have it all brought together and laid out, and to see that yes, there was a rise in the number of young people in this group who come to the court in child protection proceedings about 7 or 8 years ago, and that's been sustained. I took on board what one of the contributors said was that we shouldn't necessarily think it's a good thing for people to be drawn into the criminal justice system or the family justice system. And we are right to have that word of caution. But if they're going to be drawn into one or other, I'd rather they came to the family justice system if they're teenagers than into the criminal justice system. And here the voices of the young people were very telling. We need to know more about what it's like to be in the care process, what we could do better for the families, what their perspective is. Equally, the contribution from Judge Hilary Watson in Coventry about the FDAC intervention and directly involving the young people is, I think, inspirational and one that we could all reflect on and see how we could develop that. It was dynamic, it seems, in terms of the relationship that the young people had with their social workers. What we do when they're in the proceedings is, of course, crucial. And then the next stage is what happens at the end of the proceeding. Do we make a care order or not? What is the care plan? And for some of these young people, they are extremely troubled. And the care plan, the placement, is very tricky. We have an increasing number of young people who need to have their liberty restrained in some way, dolls, in various settings, not secure accommodation, but something that protects them, but nevertheless protects them from themselves by restricting their liberty. These are really tricky cases, and we need to learn more about that. And then also we need to understand what happens afterwards. Once the care proceedings have finished and we've all walked away, what happens to the young people? And there again, some of the voices there were very telling. So although this may not be news that we've seen today, it is very, very valuable to see it collected together and laid out in sequence, albeit snapshots, but very clear snapshots, so that we can see what we're doing. The evening that's been presented is a wake-up call, I think, for all of us as to just what is going on and how we can look to find out more and improve our practice. More research is, I think, essential. We've tantalizingly seen glimpses into each of these areas, and there's a real need to drill down further. Of course, I have no control over these matters, but I would have thought that the FJO would be well advised to see if there was an appetite for MPs and government officials to see this presentation. It is very accessible and clear, and it shows what we're doing in the family justice system. It shows how gritty and difficult it is. Sally Jenkins' contribution from Newport and the way she described it just shows, A, how important it is for these young people who fall between crime, mental health and care, and how tricky it is to find out what to do. It is, I hope, the beginning of yet further work by the Family Justice Observatory to lead us on by shining a light on all these areas. So I'm very, very pleased that they've done this work, and I'm pleased to be able to play this small part in it this evening. Thank you.
Thank you, Sir Andrew. Now I'm pleased to introduce our discussion panel. We have Her Honour Judge Carol Atkinson, who is DFJ for East London, Shona Gallagher, who's Director of Children's Services at South Tyneside Council, and you'll see Celia Parker and Joe Tunnard, who are Senior Associates at Research in Practice, who are still with us. Now we're going to try and answer as many questions as we can in the remaining 20 minutes or so, and I can see a lot of questions have already been put in the Q&A tab. Let me start by some of the issues that were raised by the young people in the earlier film, particularly their questions around and comments around wanting to have a voice and be heard in proceedings. Perhaps I could start with Judge Atkinson. What can the judiciary do to ensure that young people not only have a voice in proceedings, but feel heard in such complex and difficult cases?
I think that any will tell you that we are very happy to meet with young people for precisely that reason. I mean, the project that Hilary Watson described to you is an extension of that, if you like, within the FDAC setting. What I find, though, is that people are often, the young people are often not encouraged, or there's not enough work done, I don't think, on the ground to ensure that they understand the opportunity to be able to speak to the judge. When young people come to see me, it's for two reasons, I think. They want to be heard. They know I know what they think from someone else, but they want to be heard. And the first thing I tell them is never ever underestimate how valuable it is to meet the young person, because it makes their whole case come alive. One young person talked about being a number. Interestingly, they didn't mention the judge in their conversation, but they talked about being a number. And the fact of the matter is, we deal with so many cases, there is always that danger. I really think if you meet the young person and speak to them, the case really comes to life for you. And the second reason they need to meet the judge, I think, is to have faith in the process, have faith in the decision maker, understand how the process works. But I was interested, Lisa, listening to that conversation between the young people. The focus was on the relationships that they had before they got into the courtroom. And undoubtedly, we are judges, we make the decisions, and we're seen from that perspective as very important. I understand that. But really, the important people are the people on the ground working with these young people before they even get into my courtroom.
So let me pick up on that point and ask Shona about that, because the young people were very clear that they were struggling to build a relationship with the professionals around them, partly because they felt they had nothing to hang a relationship on, very little information. How do you address that in South Tyneside?
Well, I think there's lots of information about this in the chat as well. And I think we all know in the sector the importance of relationship-based practice to young people. And it was very interesting listening to Mike in particular, because that echoed what a lot of young people had told us. And one of the things that we've done in South Tyneside as a way to address that is two things, really. We've introduced what we call the Magna Charta, which is our commitment to young people about how we will manage change. Of course, we don't want social workers to change, but we can't stop that from happening. There will be change for young people, but what we can control is how that's done. And the other thing that we have done is introduce what we call Know Your Social Worker, IRO, cards. So all of our social workers, when they join the authority, have their picture taken, and they have to put 4 things on the front of this card that is about them as a person. And on the back is how they contact the social worker. And we have an expectation that they will use this as a discussion point with children and young people. And children and young people have fed back to us that this is a really important point of relationship building, because as Mike says very powerfully in the video, we know a lot about young people. It is only fair and right in relationship-based practice that they are told something about the people who are making decisions for them and with them.
Thank you. If I could ask Celia about this, because I mean, it's difficult in an audit to measure the quality of the relationships that young people have. But I was struck by the point that you made in your presentation, both you and Joe, about family group conferencing and the value of that. Can you say a bit more about that?
Yes, in all 4 of the local authorities were using family group conferencing before proceedings or during proceedings. But there was a difference in that 2 of the local authorities had only done a conference with 1 family. Another local authority had done with about half the families. But one local authority did shine out in as much as every family had had a family group conference except just 1. And that wasn't because it hadn't been offered multiple times, but that family was resolute in refusing to participate in a conference. But for all the rest, they had at least 1, sometimes 2 conferences. And all the evidence pointed to the strengths in a family group conference and the positives that arose. There wasn't always a placement for a child who couldn't remain with their parents, but there was always support with a transition in moving from one parent to another, or to a connected person, for example. And it was a real shining example of positive practice that we felt should be well bedded in local authority work.
Now, the audits you did, Jo, focused on areas of deprivation, and I can see from the chat there's lots of comments about the impact that poverty is having on family life. What is the message from the research in terms of the relationship between poverty and what services can be doing in that context? Jo?
Oh, that's a big one, Lisa. From our audit of 73 children, what we found was all their parents, their families were desperately suffering from poverty, discrimination, deprivation, all those things that inevitably have an impact on your life and your life chances. What can we do about it? Well, we can end austerity, we can put children and families' needs first in the way that they should be put first. We can level up in a way that we've had it promised. We can do all of those things. You know, it's not quite for us looking at 73 case files to come up with those answers, but we do have answers from the children and from the parents and from the professionals about how we can transform some things. So, for instance, the president is pleased that we've got all these extra young people in his system. Well, that's great. Let's think about how we might transform the system, the family justice system, in a way that children, older children, and their parents are desperate for it to change. I could say something on supervision orders, but I think I'll stick a bit broader, if I may. I think what we can do, and we can make some change here, I think what we can do is do away with the adversarial practice in the family justice system, and we can replace it with problem-solving practice. And if we do that, we can shift the ethos of standard care proceedings in the right direction, in the way that older children and their parents and the rest of us, most of the rest of us, want to see happen. And so I think it's timely for all of us, 382 of us tonight, to think what we can do tomorrow to try and do more about that shift, so that in court, parents and older children, if they turn up too, are welcomed when they get to court, are asked how they are. If they're a parent, they're asked how their children are. They're asked if they're comfortable with the people who are with them, their advocate, their translator, whoever else is there with them. They can be invited to sit at the front because they're the important people rather than sit behind other people. They can be asked questions during hearings. Now, everybody may be doing this already. It certainly happens in problem-solving courts, but it doesn't really happen in standard proceedings. And if we started to do that, then I think what we'd end up with is a start so that everybody in court is treated with humanity. That's what the young people wanted. That's what parents wanted. They want not to be broken by being involved in court proceedings. They don't want the fragile pane of glass that they are, as Mike said, to be broken by what people are doing to them. And they want to be seen as people who've got something to offer, who have strengths, and just happen to be at a difficult stage of life. And let's do this from tomorrow, Lisa, if I may say so. Tomorrow's the 14th of October. To remember what that is, it's the date 30 years ago tomorrow that the Children Act 1989 was enacted. Well, let's not wait 30 years. but let's move away from the adversarial way of doing care proceedings in what, 3 years? Shall we go for that?
Thanks, Jo. Let me turn to Carol, because specifically on problem solving courts, it was very striking that Hilary Watson's example was within an FDAC type context. But you made a very important point earlier about this being not just about what happens in the courtroom, but what happens prior to that point. How can we ensure that we're all working together to change the experience for young people, so that across the system, there's a sense that they have their voices heard, some agency and a real humanity embedded across the system?
Well, I think, Jo's idea about problem solving is a great idea in the court context. It undoubtedly, in my experience, will work in many cases. I'm not sure it will work in every case, particularly some cases that I deal with. However, it's not enough to say, let's wait till they get in the courtroom. It all starts well before then. That's when we need to be talking. That's what we need to be talking about. We need to be talking about the provision of these things to parents and to children before they are on their way to the courtroom. We need to be talking about early intervention. All of that, the stuff that we've read about how, in fact, the vast majority of these children, there have been problems in their lives from the beginning. Anyone who's read that thematic review from one of my local authorities, Croydon, it is absolutely heartrending. Where were you when I was 6? Where were you when I was 2? It's way back. So actually, I'm sorry, Jo, I think what you're saying is great, but I'm banging the drum in favour of actually trying to solve people's problems before they get to the courtroom. I don't think it's too late by the time they get to the courtroom. I think what judges can do, there's a whole range of stuff that judges can do. I agree with Hilary in that respect, but we can only work with what we're within the rules that we're allowed to work with, and we can only work with what we're given. So if you don't have anywhere to, sometimes for the vast majority of the children in this age range that I have to deal with, if I could solve their problem with a bike, it would be great, but I need to find somewhere where they can be safe. The idea of having somewhere in Newport, creating their own safe places, that's the sort of thing that I'd be interested in. But by the time you get to our end, it's not too late, but it's very much harder.
Thank you. If I could turn to Shona now. We saw the figures in Alice's presentation about the trends in young people coming into care proceedings, and the fact that the North East is very much an outlier, and she gave some reasons why that's the case. But it seems to me that making progress in the North East is going to be the real guide star for us. This is where we most need to make change happen for a whole generation of young people. Do you feel optimistic about the future?
Well, I'm a bit of an optimist, so I do, and I think that Jo would have been getting a round of applause if we'd been in a real room, because I agree with everything that she said about, and I also think, if I may, that the adversarial system also damages relationships, sometimes important relationships for social workers with children, because and I also feel that we value the wrong things in the system. We measure orders, not outcomes, and whilst we measure those things, then those are the things we will value. The North East has made a submission to the care review. For anyone who hasn't read it, I urge you to read it, and it draws on a really important point that's brought out in the chat about the link between poverty and deprivation and outcomes for children and young people across the whole system. In the North East, we have higher numbers of children cared for than in the rest of the country. It is unsurprising we have higher numbers of care proceedings, not just for older young people, but across our system. I also agree with June's comments in the chat that one of our challenges is where we piecemeal fund solutions to problems and we look for a reactive solution to things, then we will never address the proactivity about what we need for children and young people. So whilst I'm always hopeful, I do think there is some system change that needs to happen. And I do think that we need to see what happens for children as a system there is too much diversion into this being good local authority, bad system. It needs to be a much more holistic approach. That's what young people have been telling us for a long time now, probably the whole 30 years since the Children Act. And it's what they're still saying. It's about time we all listened.
Well, I think that is a perfect note to end on. I'm really sorry that we can't continue the conversation, because on our panel we have got some amazing perspectives and some real insightful and very inspiring messages from them. But I'm afraid it is time for us to finish the webinar. Thank you all very much for attending. Thank you obviously to our panel, our presenters and contributors, Sir Andrew McFarlane and everyone else who took part. If you'd like to download our research, please go to our website, nuffieldfjo.org.uk. This is very much a first step in an ongoing project to inform change in the way the family justice system responds to older children and young people. So to be kept informed of upcoming research, please sign up to our regular bulletins at nuffieldfjo.org.uk/subscribe. We would be really grateful if you could fill in our event feedback form. We are constantly looking at ways to improve our events for you, and we look forward to welcoming you to future webinars. Thank you.